Imagine this, you're at work and you notice you're being treated differently, not because of performance, but because of who you are. Maybe you're denied promotions, paid less than others, or even fired. It feels unfair, but you're left wondering, how do I actually report workplace discrimination? Here's the truth. Under U.S. law, discrimination based on race, sex, age, disability, religion, or other protected characteristics is illegal. And there are clear steps you can take to stand up for yourself. From reporting internally to filing a complaint with the Equal Employment Opportunity Commission, EEOC, or your state agency. The process is designed to protect you and hold employers accountable. In this video, I'll explain exactly how to report workplace discrimination, what protections you have along the way, and how to build a strong case. Part 1. Recognizing discrimination and why reporting matters. Before you can report discrimination, you need to know what qualifies under the law. Not every unfair decision is illegal. Workplace discrimination happens when an employer treats an employee unfairly because of a protected category, like race, color, sex, pregnancy, sexual orientation, gender identity, religion, national origin, disability, genetic information, or age 40+. These protections come from laws like Title VII of the Civil Rights Act, the Americans with Disabilities Act, ADA, and the Age Discrimination in Employment Act, ADEA. Discrimination can appear in many forms: hiring and firing, refusing to hire someone because of their age, or firing a woman after she announces a pregnancy. Pay and promotions, paying men more than women for the same job, or denying promotions to older workers. Job assignments and training, giving less desirable shifts to certain groups, or excluding employees with disabilities from training opportunities. Harassment, repeated sexual jokes, racial slurs, or creating a hostile work environment. Why is reporting so important? First, the law requires you to act quickly. Complaints usually must be filed within 180 days of the discriminatory act, sometimes 300 if your state has its own agency. Waiting too long can mean losing your rights. Second, reporting helps create a record. If your employer claims you were fired for performance issues, but you have documentation showing you complained about discrimination shortly before, that timing can support your case. Finally, reporting isn't just about you. It helps hold employers accountable and can prevent others from facing the same unfair treatment. The EECC and state agencies rely on workers stepping forward to enforce the law. So, step 1 is understanding whether what you've experienced counts as illegal discrimination. Once you recognize the signs, you're ready to start the reporting process. Part 2, internal reporting, HR, supervisors, and creating a paper trail. Once you suspect discrimination, your first step is often to report it internally. Most employers are legally required to have anti-discrimination and anti-harassment policies in place. These policies usually explain how to file a complaint with a supervisor, a manager, or the human resources department. Why start internally? Because the law expects employees to give their employer a chance to fix the problem before escalating it. Courts often ask whether the employee reported the issue and whether the employer responded reasonably. If you never reported it, your employer might argue that they didn't know, which can weaken your case. When making a report, the key is to create a paper trail. Instead of only talking to HR verbally, put your complaint in writing, by email, a formal letter, or even an internal HR portal. Be clear and specific. Describe what happened, when it happened, who was involved, and why you believe it was discriminatory. For example, instead of writing, "I feel I'm being treated unfairly," write, "On March 3rd, my supervisor assigned me fewer hours than my male coworkers, even though I have more seniority. When I asked about it, he said, women shouldn't work closing shifts. I believe this is sex discrimination under Title VII." That level of detail makes it much harder for the employer to dismiss your complaint as vague or subjective. Also, keep copies of everything: your emails, HR responses, and any performance reviews or disciplinary actions that follow. Sometimes employers retaliate against employees after a complaint. Retaliation itself is illegal, but you'll need evidence to prove it. If you're worried about going directly to your boss, especially if they're the one discriminating, report to HR or use anonymous hotlines if your company has them. Larger employers are required by law to take these complaints seriously and investigate promptly. Internal reporting doesn't guarantee results, but it does two critical things. One, it puts the employer on notice, legally obligating them to act. Two, it strengthens your legal protection because you followed the right steps. If your employer ignores your complaint, fails to act, or punishes you instead, that's when it's time to take your case outside the company and file with a government agency. Part 3. Filing a complaint with the EEC or state fair employment agencies. If internal reporting doesn't fix the problem, or if the discrimination is especially severe, the next step is to go outside the company and file a complaint with the Equal Employment Opportunity Commission, EEOC, or a state-level agency known as a Fair Employment Practices Agency, FEPA. The EEOC enforces key federal laws like Title VII of the Civil Rights Act, the ADA, the Age Discrimination in Employment Act, and the Equal Pay Act. If you were discriminated against because of race, color, sex, religion, national origin, age, 40 plus, disability, pregnancy, genetic information, or related retaliation, the EECC is where you file. Here's how it works. You must file a charge of discrimination, which is a formal statement describing what happened. This can be done online, by mail, or in person, at an EECC office. Deadlines are strict, usually 180 days from the discriminatory act, but up to 300 days if your state has its own FEEPA that works with the EEOC. Missing these deadlines can mean losing your right to bring a case. Once you file, the EECC notifies your employer and begins investigating. This can include requesting documents, interviewing witnesses, or visiting the workplace. In many cases, the EECC will first suggest mediation, a voluntary process where you and your employer meet with a neutral mediator to try to resolve the issue quickly. If mediation fails, the investigation continues. At the end of the process, the EECC may find cause and try to settle with the employer. File a lawsuit on your behalf, rare due to limited resources, or most commonly, issue a right to sue letter, giving you permission to file a lawsuit in federal court with your own attorney. State FEPAs often provide similar protections, sometimes broader than federal law. For example, many states cover smaller employers, fewer than 15 workers, or include extra categories like marital status or sexual orientation, even before federal law required it. Filing with a state agency usually dual files your case with the EEEC, so you don't have to do it twice. The important thing to remember, filing a complaint is not just about your job. It also helps regulators uncover patterns. If multiple employees at the same company file similar charges, the EECC may open a larger systemic investigation. So, if internal complaints fail, the EECC and state agencies are your next line of defense. They make sure employers can't sweep discrimination under the rug. Part 4. The role of lawyers and when to consider legal action. While the EECC or a state agency is often the first stop, sometimes the most effective way to protect your rights is by consulting an employment lawyer. Lawyers understand the legal system, know how to strengthen your case, and can help you recover compensation if your employer broke the law. So, when should you think about hiring an attorney? There are a few key situations. If the discrimination was severe and caused major harm, like losing your job or significant pay. If your employer retaliated against you after you filed a complaint. If the EEOC issues you a right to sue letter, which gives you 90 days to file a lawsuit in federal court. If you need help negotiating a settlement or calculating damages. Employment lawyers often work on a contingency fee basis, meaning they only get paid if you win or settle. That makes legal help more accessible, even if you've lost income because of discrimination. What can a lawsuit achieve? Depending on the case, you may be entitled to back pay for lost wages and benefits, reinstatement to your old job if you were fired illegally, front pay if reinstatement isn't possible, compensatory damages for emotional distress or harm to your reputation, punitive damages in cases where the employer acted especially maliciously, attorney's fees and court costs, which many statutes allow the losing employer to cover. A lawyer can also help with settlements, which are common in discrimination cases. Employers may prefer to settle to avoid bad publicity or costly trials. Settlements often include monetary compensation, but they can also involve non-monetary terms like policy changes, training requirements, or positive job references. It's also worth noting that legal action doesn't always mean a long, drawn-out trial. Many cases are resolved during the EEC process, through mediation, or shortly after filing in court. Having a lawyer signals to the employer that you're serious and can often lead to a quicker, fairer outcome. The bottom line, while you can navigate the process on your own, an attorney can greatly improve your chances of success, especially if you've faced retaliation, financial loss, or lasting harm. Legal action isn't about revenge. It's about accountability, fairness, and making sure your rights are respected. Part 5. Practical tips for workers plus real-life examples. Reporting discrimination can feel intimidating, but you're not powerless. Here are some practical tips that can strengthen your case and protect your rights. 1. Keep a journal. Write down every discriminatory incident with dates, times, names, and details. The more specific you are, the stronger your case becomes. 2. Save evidence. Hold on to emails, texts, performance reviews, or schedules that show unequal treatment. If policies are applied inconsistently, those documents can expose discrimination. 3. Identify witnesses. If coworkers saw or heard discrimination, ask if they'd be willing to provide statements. Witness support can make a huge difference. 4. Act quickly. Remember the deadlines. Usually 180 days to file with the EEOC, or 300 in some states. Waiting too long can close the door on your claim. 5. Stay professional. Even if you're angry, try to remain calm and professional when reporting. This prevents your employer from claiming you were fired for misconduct instead of discrimination. 6. Protect yourself from retaliation. If your employer cuts your hours, demotes you, or fires you after you complain, that's retaliation, and it's also illegal. Keep records of any changes after you report discrimination. Now, let's look at some real-life examples where workers took action and won. A group of women at a financial services company discovered they were consistently paid less than men in the same roles. They filed complaints under the Equal Pay Act and received millions in back pay and damages. A pregnant retail worker was fired after requesting light duty. The EEC sued on her behalf, and the company had to pay damages and revise its policies to prevent future discrimination. An older worker passed over for promotions, filed an Age Discrimination in Employment Act claim. The court found clear bias in the company's hiring practices, leading to both compensation and mandatory management training. These cases show that reporting discrimination isn't just symbolic. It can lead to real justice, financial recovery, and lasting workplace changes. The lesson is clear. If you face discrimination, don't stay silent. By documenting, reporting, and taking action, you not only protect yourself, you also help create a workplace where fairness and respect are the standard, not the exception. So, how do you report workplace discrimination? The process starts with recognizing it, then documenting everything and reporting internally through HR or your supervisor. If your employer ignores it, or worse, retaliates, Your next step is filing a charge with the ECC or your state's Fair Employment Agency. From there, you may pursue mediation, investigation, or even a lawsuit with the help of a lawyer. The most important thing to remember is this: the law is on your side. Discrimination based on race, sex, age, disability, religion, or other protected categories is illegal. By taking action, you not only protect yourself, you also hold employers accountable and help create fairer workplaces for everyone. If this video helped you understand your rights, hit like, share it with someone who might need it, and subscribe for more plain English guides to workplace law. And in the comments, tell me, what barriers do you think stop workers from reporting discrimination?